copyrights and patents are important protections for inventors, authors, and all sorts of creators. In the case Cox Communications versus Sony Music Entertainment, I'm reminded of the response Willie Sutton gave when asked why he robbed banks. Because that's where the money is. This case seems more like a shakedown than the protection of copyrights. So we'll look at this case next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach your action generation be free. Glad you could join me today. You know, copyrights and patents, they're important, and they deserve their full protection. But should that be used to shake down other entities? That's kind of the basis of the case here, and I'll get more into that. If you want to find out more, if you want to check my sources, we can find the article at constitutionstudy.com. I've got links to all of my sources, and you can, of course, double-check my work. Now, I'll talk more about the website and some other ways you can support the work that we're doing here at the Constitution Study at the end of the episode. But for now, let's take a look at Cox Communications versus Sony. As an author, I'm familiar with the idea of copyright, my legal authority to control what I've created. Now, let's start by defining where the power of copyrights come from. From Article 1, Section 8 of the Constitution, Congress has the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Congress has the power to promote science and useful arts, not by funding them, but by giving the creators exclusive rights to their creations, for a limited time, of course. Now, this case started in 2018 when members of the music industry, collectively referred to as the plaintiffs or Sony, sued Cox Communications. Their claims are for vicarious liability and contributory infringement arising out of alleged copyright infringement by defendant subscribers. What is this vicarious liability Cox is accused of? Vicarious liability holds a defendant accountable for third-party infringement if he, 1, possessed the right and ability to supervise the infringing activity, and 2, possessed an obvious and direct financial interest in the exploited copyrighted materials. So the courts say that you can be held liable for someone else's infringement if you were able to supervise their activity and had a financial interest in the exploit of the copyrighted materials. Remember this, as it will become important during the arguments. The district court found that Cox's method of terminating their user accounts on a case-by-case basis wasn't standardized or aggressive enough to immunize Cox. While the district court found Cox liable, the Fourth Circuit split the decision, claiming that Cox was not vicariously liable but directly culpable because they continue to supply internet access while knowing people will use it to infringe on a copyright, which brings us to the Supreme Court.
Thank you, Mr. Chief Justice, and may it please the Court. The Fourth Circuit held that a provider of basic communications infrastructure to millions of homes and businesses can be held liable because it did not kick enough accused infringers off the Internet. No notion of tort or copyright law ever conceived can support that theory.
This is a fundamental issue of liability. Sony does not claim that Cox did nothing to help them protect their copyrights, only that they didn't do enough.
This court explicitly rejected the theory in Twitter where it said, quote, plaintiffs have identified no duty that would require communication providing services to terminate customers after discovering that the customers were using the service for illegal ends. This court said in Grokster that liability cannot be predicated on, quote, mere failure to take affirmative steps to prevent infringement. Reaffirming those basic principles resolves this case. No case has suggested that knowledge alone can create the necessary culpability to find someone liable for infringement.
Mr. ROSENKRANZ claims that simply knowing that illegal things are going on is not enough to create liability. Again, another point to keep in mind as we go forward.
The consequences of plaintiff's position are cataclysmic. There is no surefire way for an ISP to avoid liability, and the only way it can is to cut off the Internet, not just for the accused infringer, but for anyone else who happens to use the same connection. That could be entire towns, universities, or hospitals.
Imagine having your internet connection turned off merely because someone in your home has been accused of copyright infringement. Not convicted, not adjudicated, but merely accused of copyright violation. Does that sound like justice?
Turning Internet providers into Internet police for all torts perpetrated on the Internet will wreak havoc with the essential medium through which modern public engages in commerce and speech. This court should reverse. I welcome the court's question.
Obviously, since Mr. Rosenkranz is representing Cox Communications, he believes the court should reverse the decision of the Fourth Circuit. Next up, we have Mr. Clement on behalf of Sony.
Mr. Chief Justice, and may it please the court, this court's cases recognize that liability for copyright infringement is not limited to direct infringers, but extends to those who induce, cause, or materially contribute to the infringement of others. And a classic form of material contribution is to provide the means of infringement to a specific known infringer, knowing that infringement is substantially certain to follow. That combination of knowledge of a specific consumer and an ongoing relationship is critical to distinguish culpable conduct from simply engaging in a one-and-done sale of an item that can be used in a way to infringe but is generally used lawfully.
Quite a bold statement. If you assist a specific known infringer to infringe, you are considered liable. But is that what happened here? Did Cox assist a specific user in order to establish culpability? Or did they merely not turn off a service used by the alleged copyright infringer, an accusation not yet proven in court?
Now, on this record, it is beyond dispute that Cox provided the service to known infringers with substantial knowledge that what they themselves called habitual abusers would continue to infringe. That reality, along with a record chock full of Cox's admissions that it held the copyright laws and the DMCA in contempt, is what requires Cox to insist on the extreme position that they can continue to provide service to habitual abusers in perpetuity without consequences.
Another bold accusation, claiming that Cox Communication held both copyright law and the Digital Millennial Copyright Act in contempt. I wonder if he has the evidence to prove that, because the only people that seem to know that these people are infringers is Sony, an accusation they have not yet proven.
That rule has nothing to recommend it and was admitted today would render the DMCA and the cooperation it is intended to foster a dead letter. Why bother with a safe harbor? Why worry about a limitation on liability, which is the express text of the DMCA, if there's no liability to limit? Why bother cooperating with copyright holders? Why bother having a reasonable and appropriate system for taking down repeat infringers if you're allowed to behave entirely unreasonably? So in all of this, you see that the position that's being advocated by Cox is a product of the record in this case. If Cox is right on the law, then Cox could take tens of thousands of copyright notices and throw them in the trash, and they could have its employees say, F the DMCA. That is, in fact, what the record says, which is why they're asking you for an extreme rule. I welcome the court's questions.
Many bold and colorful claims, but do they hold up during questioning? See, much of the questioning revolved around what Cox Communication had or had not done in response to these copyright notices.
That's true sometimes. It's not true other times. And there's no evidence that it's true here. In other words, there are plenty of times where you're getting that there's a link to a specific individual, and you know who that individual is. You would not have to cut off anybody else, and you know that individual has infringed.
Your Honor, I beg to differ. There is literally not a single place in this record where a specific individual was identified. If you, let's take the smallest unit, a household, you still don't know who the individual is.
Part of the problem is identifying who is actually committing the alleged copyright infringement. The smallest unit for an account is a household, which may include many members, one of which may be committing copyright infringement. Yet Sony appears to want the entire household disconnected from the internet because of this. Now, if there was good reasoning about that, what about a hotel, university, or an entire ISP? Should they lose their internet access because of allegations against one of their users? Justice Sotomayor thinks there are things that could have been done.
There are things you could have done to respond to those fringers, and the end result might have been cutting off their connections, but you stopped doing anything for many of them. You didn't try to work with universities and ask them to start to look at an anti-infringement notice to their students. You could have worked with a multifamily dwelling and asked the people in charge of that dwelling to send out a notice or to do something about it. You did nothing. And in fact, Counselor, your client's sort of laissez-faire attitude towards the respondents is probably what got the jury upset. Meaning you're talking something very different than Twitter, where it's not even clear that their websites were being used for the specific attack at issue. Here, you know that a particular location is infringing, and most of the time you're doing nothing. Why aren't you contributing to that infringement?
Another example of an accusation without any evidence from Justice Sotomayor, as Mr. Rosenkranz pointed out.
The notion that Cox did nothing is absurd. I will mention just 3 facts that are undisputed. First, Cox invested its own resources to create the first of its kind anti-infringement program. There was no precedent for that. Second, under that program, Cox sent out hundreds of warnings a day. To your point, Your Honor, that we didn't work with universities, we most certainly did. The first several steps, the 13 steps, are all about contacting them, cutting them off, that is, suspending their accounts, which we did 67,000 times in the course of this period. That's thousands every month. And third, the program stopped infringement by 98% of the people who were accused of infringement. That is not nothing, Your Honor.
Another consideration for culpability is whether or not the accused has a financial incentive to assist in committing the crime.
Is there evidence in the record that you have a financial incentive not to terminate infringers?
We have a financial incentive, like any business does, to keep our customers. But the Fourth Circuit found, and this was a basis for rejecting vicarious liability, that we did not have a financial incentive to increase infringement.
Justice Sotomayor seems to think that if one person is accused of committing a crime, everyone should lose their internet access to stop the one accused.
Meaning, if you know that a particular location and someone in it is committing a crime and you're supplying to that person, and perhaps others, it doesn't matter what the others are doing, but you know some person in that home is infringing, why aren't you participating by giving them the tool to infringe?
Well, because, Your Honor, that it needs to be an act that unequivocally demonstrates
Why?
a purpose.
Justice Jackson pursued a similar line of questioning. According to Justice Jackson and Sotomayor's logic, your city is liable because they build and maintain roads even when they know people are going to drive drunk on those roads. At least your city does have law enforcement powers, but ISPs do not. I tend to be concerned when I see multiple justices trying to regulate an industry when they obviously have no clue how it actually works. Let's start with Justice Jackson.
And your argument is knowledge plus providing the service, internet service, is not an affirmative act. Do I have that right?
That is correct. We are providing the internet service and declining to terminate. That's what we were held
to individual customers or ISP addresses, which makes it, some would say, different than Twitter, because Twitter was just, they were putting up a platform that people were using. But you've got contracts with individual people that you're providing internet service to, correct?
Apparently, Justice Jackson thinks every individual has their own internet account with their own ISP address. She probably means IP address, but we'll let that one go. Now, Justice Jackson goes on.
But I mean known in ways that you can isolate the ISP address and the places where the infringement is coming from.
We know the IP address. If it's a regional ISP, there are 10,000 possible homes or businesses who could be infringing. And as I was saying earlier, that's the first that will have to get cut off under this liability scheme.
Depending on the network and its connection to Cox Communications, the customer could be anyone from a single home to a business and even entire internet service providers. Now, should the justices of the Supreme Court have their internet access in the courthouse disabled because someone on their network is accused of downloading copyrighted materials? Justice Alito tried to tease that out during his questioning of Mr. Clement.
What is an ISP supposed to do with a university account that has, let's say, 70,000 users? What is the university supposed to do in your view?
The university is supposed to, under those circumstances, the ISP is supposed to sort of have a conversation with the university. Now, the ISP's policy to the university says you can't use this service or allow your service to be used for copyright infringements.
So a university can have thousands of devices connected through their internet account. What is the ISP supposed to do? Legally, what can they do? Can they terminate a contractual arrangement because of a single bad actor?
That's how it works in practice.
How does it work in practice?
Well, the way it works in practice is with, let's say, let me take something that I know a little bit better, like a hotel. And so, like, a hotel has lots of guests. So the hotel is provided internet service, and the hotel then can do things starting with terms of use, but a lot of hotels actually don't provide their guests, at least in a normal way, don't provide their guests with services at a speed that are sufficient to do peer-to-peer downloading, precisely because they don't want to be in the position of having guests that are staying there largely so they can sort of upload and download copyrighted works.
Except peer-to-peer downloading long predates the high-speed internet access most of us have become used to. In fact, many of the protocols used for peer-to-peer sharing were designed with slow and unreliable internet connections in mind. Meaning, slowing down a guest's speed just means the download takes longer. It doesn't prevent the sharing. And what about those who are legally sharing information this way? Should they be restricted because of their bad actions of others? So if the problem is in households, hotels, and universities, why is Sony suing Cox Communications?
If you lose, what is the effect on your copyright holders? Like, you know, because you monitor and then send the ISPs the accounts that are downloading the copyrighted material, right? So you could still try to protect your copyright, but it wouldn't be as deep a pocket and it would be a lot worse, right? If you had to go after the individual users themselves, but you wouldn't be without recourse.
We would be without scalable functional recourse. And if you look at the Seventh Circuit's Aimster decision, like even back then, Judge Posner had a nice phrase for what direct infringement is, which is it's a teaspoon solution to an ocean problem. So if my clients are limited to direct infringement actions, they are in very, very dire straits.
In other words, it would be too hard to actually sue those violating copyright laws. So Sony decided to go after the deeper pockets. Just like Willie Sutton, Sony is suing Cox because that's where the money is. And just what does that say about Sony and their lawsuit? But there's more.
The copyright holder notifies the ISP that this particular account has, over the course of 6 months, has violated the copyright 50 times. And the ISP does nothing in response to that notification. And then after the 50th notice, it begins to send out just a very tepid warning. What you're doing is really not very nice. But 50 more occur over the course of the next 6 months.
Did you notice that? Sony expects ISPs to terminate service based solely on their notifications that someone using that ISP has allegedly violated copyright. What happened to innocent until proven guilty? There appears to be no evidence provided that someone is using the ISP has actually violated copyright law. I get dozens of fake copyright infringement notices. These happen to be from scammers, but should my ISP turn off my service just for that? Shouldn't Sony at least present their case before punishing not only the suspect, but anyone else using their service? After all, if Sony sends me a cease and desist letter regarding some copyright infringement, I'm not punished until they prove their case in court. Now, I understand Sony's concern. After all, copyright is the only thing protecting musicians and authors' right to control their creations. That is not an excuse to blame an innocent party for not punishing innocent parties for the alleged bad actions of a few. And since when has an unauthenticated accusation been sufficient to violate someone's contract, not to mention their rights? After all, Cox users, from the single household to entire ISPs, have a contract with Cox. Should Cox violate that contract to make Sony happy? Why are so many justices on the court looking for ways to tell Cox to violate these contracts? Once again, I'm dismayed by this demonstration of the utter ignorance of the basic foundational principles of law by these attorneys and justices. You would think the supposed greatest law minds in the nation would know better. Claiming a notice from a private actor is somehow supposed to legally bind someone is ridiculous. What next? You go to jail for ignoring the note from your neighbor that your party was too loud? Maybe we should just forget courts and allow third-party accusations to be the law of the land. Let's face it, this lawsuit is nothing but a shakedown by Sony and other copyright holders because they don't want to take the time, effort, and expense to sue those actually committing copyright infringement. I mean, why follow the law when you can get courts to bully companies for you? You know, here's the sad part. Copyrights are a great thing, but they often get abused. I grew up, my family business was in books and magazines. We understood, we dealt with copyright. In fact, my family business was sued for copyright infringement. And even though they had all the evidence that it was a unique and solely created item, the lawyer said, listen, courts are likely to side with the other guy because they see a starving artist versus a corporation. It's not fair, but it's the way it is. And that's kind of what I'm seeing here today. Sony may have legitimate claims against the individuals downloading copyrighted information they hold the copyright for. That doesn't mean Cox is liable, but it's a lot easier to sue one large company with deep pockets than a lot of small individuals that don't have a lot of money. Regardless, this whole thing just seems to me like a shakedown, and I really hope that I've made my point here today. Because let's face it, if Cox can be shaken down by Sony, what's the reason Sony shaking down the Constitution study or any other entity? Copyrights are there to protect people, not to be used to intimidate others. And unfortunately, that's what appears Sony is doing. Now, if you like this type of content, I hope you support the work that we're doing here. Go to constitutionstudy.com and, well, sign up for a mailing list, maybe go to the shop and buy a book or donate to the cause. These are all the ways you can help defer the expenses we have here at the Constitution Study. Another way is to use your cell phone. See, Patriot Mobile is America's only Christian conservative wireless provider, and they share our values. In addition to having great 4G and 5G coverage and 100% US-based customer support, they take a portion of every dollar to support organizations like the Constitution Study that are defending your rights. Go to patriotmobile.com/constitution. Find a plan that works for you. See if you're eligible for a discount. And don't forget, when you check out, if you use the code CONSTITUTION, you'll get your line activated absolutely free. So support the work that we're doing here with your cell phone. Go to patriotmobile.com/constitution. Find a plan and discount that works for you. And don't forget to use the code CONSTITUTION at checkout to get your line activated absolutely free. Most of all, I hope you'll share the content we have here, share this episode, share the articles, and hey, maybe come back next time with a few friends for the Constitution Study.
Love your neighbors and have a few good friends.